All right, good morning, ladies and gentlemen. Welcome to day 5 of L2 construction series. Today's topic is managing construction claims. Now, in addition to myself and Hong Kit being the host, we have a special guest today who is Miss Yong. Now, the idea of this topic is the intention is that to share with all the audience the different perspectives from different people playing different roles. Like for example, I'm a lawyer. I'll be speaking from a lawyer's perspective in the management and the preparation of a successful claim in a construction dispute. Whereas my host partner, Hong Kit, will be sharing his view from a claim consultant point of view. Now, in addition to that, we have a Miss Tiok, who is a contract solution manager in a construction development company named Crest Builders and Rembrahat. I'm sure some of you might have already known the company in the market. So, as in most of the cases, if not all cases, you need the cooperation from all these three parties. None of the parties can actually do it themselves. You need the cooperation of the clients. A complete documentation must be there, and the witnesses are lined up who are involved in the project so as to give a complete story about what had happened and transpired on site. Whereas the claim consultant would also need to support, if necessary, the claims. For example, the loss and expense or even the EOT analysis in order to enhance the contractor's claim in a construction dispute. Now, as I said, you cannot only rely on, for example, a lawyer to pursue a claim without the cooperation of all the other parties. All of us need to work in one team, and you need to get that synergy from all the parties concerned to ensure the success of a construction claim, whether on a negotiation table with the employer when negotiating the final account or the claims that you have made, or in arbitration, if it goes to arbitration, or in court. So at the end of the day, you may have the best lawyer in town to fight the case for you. If the evidence is weak, at the end of the day, you will also likely lose the case. So therefore, as a start to formulating a successful construction claim, you must first ensure that the evidence, whether the factual or the expert evidence, must be as solid as possible. And this does not come in place at the end of the day. It has to start from the very beginning. However, in reality, we all know it is very difficult to ensure that this ideal situation happened. It is always not easy. A good construction lawyer must not only know the legal requirements for a successful claim, but also what evidence required to fulfill the legal requirements. Whereas a good claim consultant must not only have the required expertise in his field of practice, but must also be able to appreciate the issues and the facts required for the preparation of a solid expert report. On the other hand, a good construction company, right? He must know how to keep complete or good data so that at the end of the day, when the dispute arises, he can actually feed this data to the lawyer and also the claim consultant in the preparation of their cases respectively. So at the end of the day, to be that good contractor, you have to put in a lot of effort, not only in terms of the system that involves technology, but it definitely also involves your internal and also the external people as well. Now today we have a special guest, as I said, who is Miss Tiok, who will be speaking from the perspective of a construction company representative. She will share with us her learning journey to becoming that good contractor who always strive to improve their documentation record system. Now, without further ado, I shall now pass the mic to our special guest, Miss Tiok, to share her views with all of us today. But before you do that, Tiok, could you perhaps introduce briefly about yourself to the audience?
Oh, thank you so much, Violen. First of all, I'd like to say good morning to everybody and thank you for joining us today. So my background is in quantity surveying. I have close to 10 years of construction industry experience. My experience is mainly focused on building construction, high-rise especially, apartments and office buildings. I have been dealing with dispute resolution since day one of my career. So I have 1 year experience in Melbourne, and then after that I've came back to Malaysia and I've been working for Crest Builders since. And currently I am a contract solution manager handling dispute resolution and prevention. So to start, first of all, I'd like to stress that ideally for contractors, the most important, ideally we never have to do this dispute claim at all. So I like to stress that prevention is better than cure. Hopefully we never have to go down this road. But for today's main topic, I will be sharing some of the challenges and possible solutions that we might have if we have to do this report. So if you can see on the first slide, I've split there's two main root problems usually when we compile and dispute claim. One involving the people and the other one involving the documentation. Now moving on to my next slide. Under the people category, so the first one I mentioned here is change of personnel. I think this is quite straightforward. So usually let's say there's a project and then in year one is project manager A and then in year two there's project manager B. In between there's a handover process. In any event, if you're claiming, let's say for EOT, in the in-between period, there might be a problem as there might be loss of information. Second one is team mentality. So for team mentality, usually for contractors, our main focus is to complete the construction, complete the building, build, finish within time and cost. Documentation is often seen as secondary. So this is one thing where we always need to educate our team to make sure that they know that documentation is also just as important. Moving on to the next slide for documentation. Under documentation, so the first one I mentioned is lack of documentation. So when I mention this, it's very much linked to team mentality. So if they don't prioritize the documentation and the preps of it, they are gonna have not enough if there is a dispute. So documentation is very, very important and it acts as a shield for contractors to protect our hard work. Second one is documentation record accuracy. For this one, I'll give you an example. So example, a contractor is meant to they are building something and then they're meant to cast zone A and zone B today. So they cast zone A and then zone B, they couldn't do it because maybe they didn't get some confirmation from consultants or client. What happens is, then they write in for zone B. They write a letter to apply for EOT for zone B. So this is correct. No, don't get me wrong. This is actually correct, but it can be better. So for example, when you apply for EOT, they always ask for supporting documentation. And what is the support? It's most likely they'll look at the site diaries or the progress reports. So in the site diary, we're always trained to write only what we did. And we didn't record what we didn't do. So if we did do that, the documentation will be more complete and it will also help in our dispute claim. The third one I'd like to mention here is voluminous documents. So in the event, if everybody is very good, the team is very, very good, everyone records everything. And then what happens? We end up with bundles, many files of many forms and A4 papers, inspection forms, claims and everything. Maybe for each project, there might be more than 100 files. And then what if you need to look for something? How many files do you need to search through and how much time is that gonna take? So that's also a challenge for us when we compile a complete and strong dispute claim. So on my next slide, I shared a summary of all my points, of all the main points that I believe could be our challenges. So here we can see there's a few from people and there's a few from documentation. So to ensure a complete and strong dispute claim, you always need the people to do the right thing and the documentation to support it. Moving on, I'll share a bit on possible solutions on the next slide. So here, to address the people problem, what I'm suggesting is education and a lot of training on contracts. So everybody in the project or even in the office itself, everybody need to know the goals of the project. We work so hard for the project. We need to make sure that our documentation is complete as well to support it and to make it foolproof. We don't want a situation where we work so hard and then something goes wrong and then we don't have something to protect ourselves with. Second one, I'm suggesting more template documents. So this one I like to link back to my Zone A and Zone B situation earlier. So people tend to record contractors. We have a tendency to only write what we did on site. So our site diary also is formatted that way as well. I'm suggesting, is there a possible way where we add in 1 or 2 more questions in all our usual template documents to prompt the contractor to record things that did not manage to happen but was planned to, and maybe any possible reasons as well. This is very, very helpful for dispute claims in the future. The last one here I'm suggesting is the IT system. So for IT system, actually currently the company I work for, we don't have any IT system, but we do want to apply one. I mean, we do want to have one in the near future. So ideally this IT system stores all the information that we have. And then it also solves the voluminous document problem. It can help us sort a lot of things out and it can let us search for things easier. But one thing to note about IT system, the IT system needs to be the one that's suiting the people and not the other way. So for my next slide, I like to stress again, like what I mentioned from the beginning, prevention is better than cure. And this is our #1 priority. Ideally, we never have to do this dispute claim. So how do we prevent? Ideally, of course, we need to plan and we need to make sure everybody is on the same page. Communication between each other is very, very important. Everybody needs to be reminded that what is our goal. And we also need to know that documentation is very, very important to protect ourselves in the future so that we don't lose any of our progress or our profit for these kind of reasons. And the last one I'd like to share is ask for help. Honestly, if the problem is getting a little bit more complicated and we're not too sure what to do, it's best to consult somebody, maybe engage a lawyer or engage claim consultants even during the duration of the project. Lawyers and claim consultants, they're not there mainly for arbitration or litigation. If you engage them earlier, they can actually make a difference in the project outcome, or even if the project looks like it's going to fail, there is a chance that it could be saved. So they can be engaged earlier, and honestly, prevention is better than cure. Thank you so much.
Thank you, Tiok, for sharing your view. I understand that due to time constraints, you could only do it in a very summarized points, but I do personally believe after hearing you that you have actually captured the essence of what a normal construction company would encounter in terms of challenges in the documentation process in their company. Now, we also must understand that they are all Asians. When the contractor does the work, they only focus on doing the works on site without thinking too much about recording what they have actually done on site and what are the issues that have arisen. So I would say generally that Asians, especially in this part of the world, that documentation is a little bit weaker compared to the Western world. Now, we are still learning, of course, and that's why we are here today. And I cannot agree more. In fact, Tiok, when you mentioned about the last point, to engage the lawyer or perhaps a claim consultant at the very early stage or when during an ongoing project, especially when you already sense that there are something getting out of hand, that it might snowball into a big dispute if you don't manage it properly. Now, I'm not saying it this for the benefits of claim consultants or even lawyers. I can tell you, most of the times when the clients come to me, I'm a lawyer, the dispute had already come to a very big problem, and normally it's at the tail end of the project. You cannot undo things that had already happened during the course of the works. Now, just assume that you had brought in a lawyer at the early stage. You could actually potentially manage the problem so that it would not actually snowball into a big problem. Now, in fact, if that happens, the client normally would save more costs, because you see, if you want to spend money to fight a case in arbitration or in court, right? Normally that would actually cost so much more, and there would also be a lot of uncertainties whether you would be able to win the case at the end of the day. Even if you win the case, whether the other party would be in the position to pay you at that point in time already. So you also do not want to get a paper judgment at the end of the day. And I can tell you, when I do the comparison, right, compared to the clients who are more proactive in engaging their consultants, external consultants, and also lawyer at the very early stage, when a problem arises in the project, they tend to manage the project better. And most of the time, towards the end of the project, they would be able to finalize the accounts and able to settle the accounts in a better position. So as opposed to a point where I'm going to handle it all by myself, I'm just going to deal with it using my own usual practice, without looking at the contracts, without getting the consultations from the lawyer, and then you let the problem to snowball into a bigger problem. Not only that, you will not be able to resolve the accounts at the end of the day, you have to spend more money to engage a lawyer or perhaps a claim consultant to pursue a case for you with no certainty that you will be able to get back the money that you have actually lost. When I say that get back, it's not only about the probability of winning the case, but also even if you have won the case, right, whether the other party at that point in time, 2, 3 years or 5 years later, would be in a position to pay you the money. So that's why I cannot agree more with Tiok when she say that prevention is always better than cure. And it's always cheaper if you get the lawyers on board, or the claim consultant on board, or external consultant on board to resolve or contain your problem at the very early stage. Now, we have all listened to Tiok from the contractor's perspective about their challenges in compiling good documents or record good data or accurate data during the course of the works. What would a lawyer look at, and what should a lawyer do? You see, sometimes when the problems come to a lawyer, right, come to me, for example, I think what would be helpful for the client or the claim consultant is the ability of that lawyer to look at the legal ingredients for a successful claim. And they will be able to craft out in a very simplistic manner and brief the client as to what these legal requirements are and what are the information that I would like to get from the client or even external consultant to help me to fulfill the legal requirements for your case. So that's why at the end of the day, the lawyer would only need to do that and do that well. And how do they actually normally do it as the first step? As I always say, go back to the contract. You see, what happened is that contractors, they might be doing 20 projects, and don't assume that in all 20 projects, the contract is the same. The contract terms are the same. The obligations and responsibilities are the same. You cannot assume that, because nowadays we have variants of contracts. You cannot assume one particular contract that you know of very well and you apply it across the board. So that's why, as a lawyer, what we will always do is to tell the clients, this contract is different from what you have usually adopted, and be careful about certain provisions. Now, when a dispute arises, we will also do the same thing. We will look at the contracts. What are the contractual legal ingredients that you need to have to satisfy in order for you to pursue a successful claim for you? So we always go back to the contract. Now, I would like to know, actually, from the claim consultant's perspective, what would you think are the requirements that would help you to present a report in a very solid manner or in a very convincing manner? Now, on this point, perhaps we can actually ask Hong Kit, who is a claim consultant, who will be able to shed more light on this aspect. Hong Kit?
Yes, Wai Loon, thank you. Good morning, everyone. It's the 5th day of our L2 construction series. Today, I have prepared some slides to take the audience through making a claim 101 session. Let's get started. Oh, the first question is, what is a claim? Claims commonly arise between the parties to the construction contracts. This can be as a result of problems such as delays, changes, unforeseen circumstances, insufficient information, or conflicts. Claims might be made for things such as outstanding payment, variation order, loss and expense, extension of time, and LAD. Before proceeding further, ask yourself, why do we need to make a claim? Why? Can't you just dump everything in and say, okay, this is my work done, this is my extension of time, this is my loss and expense, and I deserve X amount of money and Y amount of time? Prove to me why my claim is wrong. I'm sorry, it doesn't work this way, because the burden of proof lies with someone who is making a claim, as it's not upon anyone else to disprove it. In other words, the person who is making a claim must prove its claim. For the ease of understanding, I have set out 4 very basic requirements to make a claim, namely contract, contractual entitlement, factual entitlement, and quantum. Okay, the first question, is there a contract? Whether a contract has been formed is a legal question, and I'm not going to cover this today. I'm only going to say that if there is no contract, it's not the end of the day. You may still be entitled to make a quantum merit claim. If there is a contract, look at who are the contracting parties. This may sound like a silly question, but you will be surprised that a lot of contractors have not always got this point right. A common situation is where an employer uses its subsidiary company to award a contract to a contractor. And the contractor is dealing with the employer, including taking instructions and receiving payments throughout the whole project. At the time of dispute, the contractor may think he is entitled to take a claim against the employer, only to find that the employer is not a party to the contract. Then we may also want to look at what are the terms of the contract. Have the terms and conditions of a certain standard form of contract been incorporated into the contract at issue? Again, this is often a misconception by contractors, that certain standard form of contract has been automatically incorporated into their contracts for whatsoever reason. For example, unless clear words say that PAM 206 or PWD is adopted, there will be no such terms operating under the contract. After knowing the parameters of the contract, we can now go into it and search for the contractual entitlement of the claims. Contractual entitlement is derived from the contract clauses, and the entitlement only arises when the condition precedent and procedural requirement have been fulfilled. For instance, if you intend to make a variation order claim, the first thing is to locate the contract clause. Then find out the condition precedent and the procedural requirement. When all of these are found and satisfied, it then can only be said that contractual entitlement for the variation order has arisen. Right. Again, this backdrop, let me bring you through some practical examples. On the slide in front of you, there are some sample variation order clauses. These are sample clauses I drafted for today's section, and they are not taken from any standard form of contract. I also have made some words bold and underline to bring them to your attention there. Clause 1 defines a variation order. Clause 2 provides that the contract administrator must issue a notice in writing to the contractor to effect a variation order. It also expressly says that oral variation is prohibited. In other words, variation order can only be effected by way of writing under this contract. Clauses 3 and 4 set out the conditions, precedent, and procedural requirement. It is stated that the contractor must notify the contract administrator in writing within 30 days of its intention to claim additional cost when a variation order has been issued under clause 2. Sorry, I have to go a bit fast here. And within 30 days from the date of completion of the variation order, the contractor must submit to the contract administrator its additional cost claim. Right? If these conditions, precedent, and procedural requirement are not met, the contractor's variation order claim will fail. Clause 5 further sets out the mode of services of document, which is by hand. So again, these clauses are just sample clauses. You can find it in your own contract or other standard form of contract. Right. So we have found the clauses. We know what the clauses say, and we also know the condition precedent and procedural requirement to effect a variation claim. To give you a clearer picture, I put the flow into a diagram on the slide for you here. So once the contract administrator issues a variation order to the contractor must within 30 days notify the contract administrator its intention to claim for additional cost. And within 30 days from the completion of the variation works, the contractor must submit its variation order claim. Also, not to forget, all these submissions and exchange of document must be done by hand and not by WhatsApp. The same goes for extension of time and loss and expense claims. Here, clause 6 states that the contractor is entitled to claim for extension of time if the delay is caused by the relevant events A to E stated in clause 7. As you can see, unlike variation order above, extension of time application here can be submitted at any time before the completion date. So following, clause 8 states the contractor is entitled to claim loss and expense only on grounds related to event A and event E. And clause 9 set out the procedural requirement to claim for loss and expense, which is within 14 days after the event ends. Again, here we have found the clauses for extension of time and loss and expenses. Loss and expense. We know what they say, and we also know the condition precedent and procedural requirement to make the claims. Again, diagram here. So for extension of time, the contractor can make its extension of time application at any time before the completion. Again, this application is to be made by hand and not WhatsApp messages. This is a diagram for loss and expense claim. The contractor must submit its loss and expense claim within 14 days event A or E ends. Right, we have just gone through the contractual entitlement for variation order, extension of time and loss and expense, which is the, we have just gone through the contractual entitlement for variation order, extension of time, and loss and expense. The contractual entitlement, which is the soul of the claim, that is not enough yet. We will now look at the flesh of the claim, the factual entitlement. What is the factual entitlement for variation order? Very simple, whether you have done the work or not. The evidence to support this includes site photo, site records, delivery order perhaps, sign-off sheet, joint inspection sheet, and etc. As for extension of time and loss and expense, the contractor has to demonstrate the relevant event has caused delay to the original completion date. Bearing in mind, not every delay is a delay to the completion date. And so only delay that affects the critical path on a baseline work program can be considered for extension of time and loss and expense. If the delay does not delay the completion date, such as the work program on the slide here, the contractor is not entitled to extension of time nor loss and expense. So we now have covered both contractual and factual entitlement of a claim. The finding of the entitlement is the determination of whether the claim has merit or basis. We will now look at quantum, which involves a determination of how much money or time the contractor is entitled. Okay, for variation order, the quantum can be determined by looking at the rate under the PQ for similar items or the schedule of rate. If none of these is available, it can be determined by reasonable market price. This can be done by calling for several quotations from vendors, suppliers, or subcontractors. If the party cannot reach an agreement on this, a quantum expert may be appointed to conduct a quantum analysis. I have tabulated a quantum analysis sample on the slide here. This involves analysis and computation of labor, material, machineries, and time cost involved for the variation. This is just an sample. Based on the quantum analysis, the contractor is entitled to 28,000 cost. As I mentioned earlier, an extension of time can be shown on a work program. This exercise is sometimes called delay analysis. For example, in the work program on the slide here, the original completion date is 16 May, but due to the 28-day MCO, the completion date is now delayed by 28 days to 13 June. Therefore, according to this sample delay analysis, the contractor is entitled to 28 days of extension of time. The direct cost for loss and expense generally includes labor costs, plant and equipment, subcontractor costs, and site overhead. This must be the additional cost actually incurred by the contractor due to the delay. I have also tabulated loss and expense claim example on the slide here. As mentioned, these are costs actually incurred by the contractor. So unlike making a payment application for items under the BQ, loss and expense items have to be supported and proven by documentary evidence. For example, to prove and support labor and management costs, it is wise for the contractor to attach salary slip or KWSP slip. In this example, the contractor is entitled for 30,000 loss and expense claim. As for indirect costs, it covers costs of head office staff and rental and utilities payment on the head office. These are the costs incurred by a contractor as part of his usual and normal business operations. The entitlement of a contractor to recover indirect costs is not always easy to determine and controversial. In fact, the second edition of Society of Construction Law Delay and Disruption Protocol, published in February 2017, it describes that there are three commonly used formulas to calculate head office overheads and profit, and they are Hudson formula, Hampton's formula, Alicia formula. I have put them on the slides here for your reference, where this can be easily found on Google. Due to the complexity and controversy surrounding the use of formulas, I'm not going to discuss them here today, but I will show you the example, the formulas here on the slides. Okay, now I will move on to conclude a simple claim report example. This is just an example. An actual claim report may come in different style and format. However, they generally have an introduction, the name of the parties, also mentioning the contracts and the nature of the works, setting out the entitlement and quantum of the respective heads of claim. So in this sample claim report, the contractor is entitled to 26,000 variation order claim, 28 days of extension of time, and 30,000 of loss and expense claim. Well, this is the end of my presentation. So I pass my slide back to Wailun.
Thank you, Hong Kit, for briefly sharing, in fact, your template of your report as well. Of course, it is not cast in stone. Every circumstances would give rise to different types of claims and different style in writing a report as well. Now, there's one thing that I'm actually asking you about your view, this particular proposition. Now, even assuming that you have prepared or you believe that you have prepared a very solid expert report in supporting a client's claim, does that really mean, actually mean that you will be able, or in most of the cases, that you will be able to convince the tribunal to adopt your view in your report?
Yes, Wailun. I think having a solid claim report is very important and necessary, but not enough. The expert's delivery and defense of its claim report before the tribunal are equally crucial. In other words, the claim report and the expert's delivery must go hand in hand. The expert must know his or her parameters before accepting an appointment and make sure he or she has the required expertise and experience. For example, a delay expert who knows nothing about quantum should never accept an appointment to be quantum expert. Otherwise, this is a disservice to the client. And when the expert knows his or her stuff, the expert will be able to deliver and defend his claim report confidently. Also, bearing in mind an expert is expert of opinion. So as long as the expert is making a conclusion or assessment from his own expertise or an experience, honestly, it can rarely go wrong. I would also like to add that, contrary to what most people think, the expert's role is not to convince the tribunal, but to assist the tribunal to determine some issues. Thank you, Wailun.
Oh, okay. Thank you, Hong Kit. Now I also would like to know from a client's perspective, meaning to say that the contractors who is also part of the arbitration. I understand that Tiok has had some actual experience, on-site experience, where she was actually required to give evidence in an arbitration whereby a claim has been brought against your company. Now, having heard what Hong Kit has said, do you actually agree with him, at least from your own experience?
Yes, I agree. So delivery of, the report itself is very important. At the same time, the delivery and the presentation of the report to the tribunal is equally as important.
I see. Okay. Have you actually encountered a case where you thought that factually, I have compiled a very good documentation, but at the end of the day, when you appear in arbitration, it doesn't turn out to be that strong anymore? And that is because also of the weakness in delivering your story and in highlighting the appropriate documents to the tribunal during the cross-examination. Do you actually feel that kind of a scenario that had happened before to you?
Yeah, it does happen actually. No doubt. Because we as contractors, we are not trained to go to arbitration, to be a witness and to present our case that happened in the last project. The project could even be 2 to 3 years. And for a project, for example, for a contractor to go into arbitration and to explain the 2-3 years happening within a few hours or maybe that few 1 or 2 days, it is not that simple to do so. And sometimes along the way, we are only human. Some points might have been missed out. Although even if the documents are all there, it's not easy for the contractor, for that one person, to maneuver around all these arbitration documents and to tell the story that he wants to tell.
I see. All right. Thank you, Tiok. I also have another question for Hong Kit. Actually, this one I looked at the questions posed by the candidates directed to me, and I would like also put it to Hong Kit. It is this. Now, everybody actually has this perception that experts report will only be required for large or medium construction claims. If the construction claim is actually very small, then you can't afford to engage the expert to fight the case for you. Now, because you don't want to end up paying your expert fees or the legal fees, which is more than the claim itself. I can share my experience actually, because it doesn't mean that the construction claim is large. Then you you only have a complex issues arising thereon. They're not necessarily. In fact, sometimes even if the claim is small, you would also involve complex issues that needs assistance from the expert as well. So in such a situation, I want to know, Hong Kit, how have you encountered such a situation? How have you actually deal or help your clients in such a case so that they don't have to give up their claim because of a lack of expert evidence to support their claim?
Thank you, Wailun. Okay, the question of whether a claim consultant is required is irrelevant to the size of the claim. As Wailun has pointed out, a massive claim and a small claim may have the same complexity issues. So I think the size of the claim should be taken out of the consideration process on whether appointing a claim consultant or not. However, making such decision based on financial and business reality can be very different. For example, a claim of 50,000, a small claim, may really not be worthwhile for bringing a claim consultant on board. But if the claim fails on this reason, this might cause some injustice to the claimant who has a genuine claim for work done. It is not an easy situation. What I have done in the past was, instead of preparing a conclusive claim report and appearing as an expert witness, I work with the client behind the scene, advising the client in enhancing, improving his claim, and this would substantially reduce the client's preparation cost, while also be able to help them to establish their case. That is my answer, Wailun.
Okay, I see. Thank you very much. And you know, we have overrun again this time around the session for about 8 minutes. I think we have to close the session for today. And I would like to extend my thanks not only to the audience who have taken the time to listen to us, but to also to our special guest, Ms. Tiok Ni, for sharing her view with our audience today.
Thank you
Now,
so much.
you want to make a remark?
Thank you, Leong, for being here with us, and I also would like to thank all the audience being with us. And today we have quite a huge turnout. We actually have close to 500 participants. Thank you for joining us. Your support is really very, very important for Wailun and I. So tomorrow we will be having Chelsea Pollard from AIAC. She's an international case counsel. She will be answering some questions, which I myself I'm keen to know. And we'll be having a special edition, a Cantonese version tonight at 9:15 p.m. It's not listed on the table, but it's on the same ID, same Zoom ID, and we will have the same password 005. We welcome you to join us if you can understand Cantonese, and it is only Cantonese. That's it for the day. Thank you, everyone. See you again. See you tomorrow.
Thank you. Bye-bye.
I will leave the screen here for a while.
Yep. Thank you. Thank you, Hongkit, and thank you, Tiok Ni. And thank you all.
See you again, Wailun. See you,
Bye.
Tiok Ni.
Thank you, Wailun. Thank you, Leong. Thank you, Tiok Ni.